Good afternoon. My name is Kate Wetz, and on behalf of the UCI Law Moot Court Board, welcome to the finals of this year's competition, and thank you for joining us. The Moot Court competition is one of the most important educational aspects of the program here at UCI Law. The competition allows students to write briefs, participate in oral advocacy, and think critically about real-world topics. The topics that the student-run board chooses are live cases that have made their way through the circuit courts, often resulting in circuit splits. This year is no different. For many second and third year students, Moot Court is the first opportunity to apply doctrinal learning by advocating for clients against a complex record. What you see today is the result of months of hard work, research, writing, and critical thinking. We are thankful for the staff, faculty, administration, practitioners, judges, and members of the Orange County legal community that helped make this competition happen. I hope you enjoyed today's event. Please join me in welcoming our Dean, Dean Richardson.
Good afternoon, everyone. Let's have more energy in this room for this competition. Good afternoon, everyone. Good afternoon. I am so excited to hear the arguments of our fabulous students, and I think all of you will be very impressed. So thank you so much for coming. And for all of you 1Ls or 2Ls who might be in this room, just imagine yourselves up here making these arguments in just 1 or 2 years. This is such an exciting time. So before we begin, and I know that we're all in for a treat, first I have to thank our sponsors, without whom this event would not be possible. The name of this event is the Experian Jones Day Moot Court Competition. So of course, the sponsors I want to thank who are here today are from Jones Day and Experian. Thank you. Could we give them a hand? Thank you so very much. We could not do this without your support. Next, I want to thank the Moot Court Board. So you've already heard from the president of our Moot Court Board, Kate Wetz, and the remainder of the board include Katie Rice, Emily Satifka, Christopher Smallwood, Farnaz Salesi, and Desiree Murray. Thank you so much for the tireless work that you did this entire year so far. And then their faculty advisor, there she is, Rachel Croskery Roberts. Again, thank you all. And then, of course, we know that it takes a village to make an event like this happen. Countless numbers of administrators, faculty, and staff work to make this event possible today. Let me name a few of them: Joe Dunn, Jillian Henry, Jenna Jones, Cynthia Ryan, Liz Schrader, and Colleen Terracani, and then all of the faculty who read and graded the briefs. Thank you very much for that. In a few moments, we'll have our 3 judges enter the courtroom, and so I'd like to introduce them all. I will do so in alphabetical order, and then they'll come in and we'll start the exciting arguments. So first, we have Justice Fybel. Justice Fybel is an associate justice on the 4th District, 3rd Division of the California Court of Appeals. He was appointed by Governor Gray Davis, and he took office in 2002. At the time of his appointment, Justice Fybel had been an Orange County Superior Court judge since April 2000. Before his judicial appointment, Justice Fybel was a partner in the law firm of Morrison and Forster, where he specialized in civil business litigation. Justice Fybel is also an adjunct professor at Chapman Law, where he co-teaches a seminar on the Holocaust, genocide, and the law. Justice Fybel received the President's Award from the California Judges Association, the Franklin G. West Award presented by the Orange County Bar Association, and the Sills Award for Appellate Excellence from the Appellate section of the Orange County Bar Association. And these are all the highest honors from these organizations. Next, we have Justice Sheryl Gordon McCloud, and she was elected to the Washington Supreme Court in 2012 after a career spent helping clients fight for their constitutional and individual rights. As a justice, Justice McCloud, she serves as chair of the Washington State Supreme Court's Gender and Justice Commission. She serves as a member of the Supreme Court's Rules Committee and as the liaison to the Supreme Court's Pattern Instructions Committee. Justice McCloud is a member of the American Association of Appellate Lawyers and a founding member of the Washington Appellate Lawyers Association. She is also on the Washington State Bar Association's Council on Public Defense. She speaks regularly at legal and community events throughout Washington State on topics ranging from ethics to criminal justice. Justice McCloud was the recipient of the Washington Women Lawyers President's Award in 2015, and she also serves as chair of the Washington State Gender and Justice Commission. In 2018, the Cardoza Society of Washington State presented her with its L'Adore Vidor Award. And finally, we have Judge Simon. Judge Michael Simon has been a judge on the U.S. District Court for the District of Oregon since 2011 after being nominated by President Barack Obama. Prior to his appointment on the bench, Judge Simon served as a trial attorney in the Antitrust Division of the U.S. Department of Justice in D.C. He then joined the law firm of Perkins Coie, where he had a trial and appellate practice in federal and state courts, handling a wide variety of business cases and several First Amendment matters. Judge Simon is a fellow of the American College of Trial Lawyers, a master in the Owen M. Panner chapter of the American Inns of Court, and he's a past adjunct professor at Lewis and Clark Law School, where he taught antitrust law. So please join me in thanking and welcoming our judges for taking the time out of their busy schedules to join us for this important event today.
All right, hear ye, hear ye. The court is now in session.
You may be seated.
The Honorable Justice McCloud presiding along with Justice Simon and Justice Fybel.
Good afternoon. We're here on the case of Bell versus Itawamba School District. Counsel for Mr. Bell.
May it please the court, my name is Paige Christie on behalf of Petitioner Taylor Bell. Your Honors, I respectfully request 3 minutes for rebuttal.
That's fine, counsel.
Thank you. Your Honors, I respectfully request that you reverse the Fifth Circuit en banc decision which granted summary judgment on behalf of Respondent for 3 reasons. The first is that Mr. Bell's speech is protected under the First Amendment. The second is that in the extreme cases where Tinker was applied to off-campus speech, they're just not factually relevant to the facts that we have here. And third, Respondent failed to satisfy their Tinker burden. Now today we have a unique opportunity to set forth a standard that protects students' speech off campus. And first, since Mr. Bell's speech it had components of public concern in it, it is protected by the First Amendment. Under Snyder—
Counsel, what remedy are you asking for?
Your Honors, I request that you reverse the Fifth Circuit en banc decision.
And are you requesting reinstatement of summary judgment in favor of Mr. Bell?
No, Your Honor. I would like a jury trial for Mr. Bell. Considering this is a First Amendment case, I think the facts of it would be best displayed in front of a jury.
So you acknowledge there's some disputed material facts?
Yes, there are. I'll address those with the Tinker burden where it appears. In terms of public concern, the Snyder case says that when evaluating speech, if the overall thrust and dominant theme of the speech is an issue of social, political, or overall concern for the general community as a whole, then it's protected. Now here we know that the reason Mr. Bell made this rap was because he was speaking about alleged sexual harassment from coaches at his high school. And we know in light of the Me Too movement that this is a very serious concern, as it should be. Now here, only matters that are purely private, that have no social issue, are not protected by the First Amendment. But here we do see that his rap has this social component here.
What about the threats in the rap song?
Yes, Your Honor. So there is language in there that the school dislikes. And in addition that
Well, it's more than dislike, isn't it? I mean, there's pistols referred to, capping, that sort of thing.
Yes, Your Honor, that's in here. But when you see what the school had asked him about, their intent wasn't the gun violence that was in this rap. What they were focused on was why he made this rap.
But does the rap contain a true threat?
No, it does not under Wetz.
Why not?
Because the context of the speech is a rap song. And we know that the Supreme Court has said rap is taken differently. In the Alonis case, we see that they said there's certain elements that make a rap, which are alliteration, metaphor, a way to vent your expressions. And that's what we see Mr. Bell doing here.
So if we follow that approach, then does that mean that the next time somebody really wants to threaten somebody, they'll do it in a rap song?
No, Your Honor. And that's what the Supreme Court had addressed in Alonis. They had seen someone posting lyrics on their Facebook page that were just straight threats. And the court looked at it and was trying to establish whether this was protected speech. And they found it wasn't because it didn't meet the elements of a rap song.
But that was not a constitutional decision. That was a statutory interpretation decision of federal law. And I think we're not here under that statute.
Yes, Your Honor. But from that, there were pieces in there where they evaluated the rap, and that's what I'm using that case for. But here, what we also see is that when Mr. Bell had brought in an expert witness to evaluate the rap, and what we saw there was the expert witness said that this was just colorful language used to entice listeners, that there was no threat there based on the lyrics.
We've seen a number of school shooting cases by fellow students. If one of them wants to terrorize their fellow students and they put it to a rap song that they're going to come and shoot up their school and blow up their school, what criteria should we assess to figure out whether or not that's protected under the First Amendment?
Yes, Your Honor, and that's a very realistic concern. Of course, nobody wants school shooters at their school. But here we have to look at the facts of this case, and the facts of this case...
No, my question is, what criteria should we adopt to distinguish between when a rap that threatens to shoot up a school is protected and when a rap like we have here is not protected? What's the criteria before you get to the specific facts? What's the general principle we should adopt?
Of course. So what I propose that you set forward would be a new style of the Tinker test. I do think there's good elements of the Tinker test. However, I feel that they are lacking. For extreme cases, if there was a true threat, the school can discipline for that. But in addition, it would have to make its way to campus. Then the substantial disruption and the foreseeable substantial disruption would be in play, like in the Tinker test. But then the school would have to show that it had an adverse effect on the campus community. And here we don't see any facts that it would have an adverse effect. Now, if there was a realistic threat and students were concerned and there would be, different elements at play there, that just, they weren't here in this case.
Is that the only thing that the school could discipline for? This rap song has the N-word in it. It was posted online with an Indian mascot, not an Indian person, an Indian mascot. Can the school have rules about the use of that kind of imagery and that word?
Not off campus, Your Honor. And here it was purely off campus. If it was on campus speech, they could censor that. If a student was saying that at school, of course, that's in their purview, but here it is not.
But every student these days in the internet age has a phone. And so if somebody posts a song like this, what difference does it make if the person's on campus or off campus?
Of course, Your Honor. So it is the modern era. I do understand people have Facebook, they have YouTube, but here there was only a probability that it would reach campus. Mr. Bell did not send it directly to the coaches.
What if there was a certainty it would reach people in the school? Does that change the answer?
Excuse me? Could you?
What if it was a certainty, not a probability, that the students would see this song or this faculty?
It would require different facts. I would have to know how that would be certain. If the student had played it on a school computer, yes, it reached campus.
Mr. Bell put it on Facebook to his friends. He then uploaded it to YouTube for anyone. Was there any realistic chance it wouldn't reach the school?
Yes, Your Honor. There was a probability that it wouldn't. And if we
What do you base that on? And where's that in the record?
Yes, so there was, since he had never directly sent it to the coaches would have to go on YouTube to see it. And in fact, we know that Coach Wildeman did not see it until halfway through the day when his wife had texted him. So nobody at the school up until the point where he discovered it had seen it. Nobody was talking about it on campus. Yes.
Let me get right to the one of the issues that's bothering me on this. Is it time to abandon the Tinker distinction between on-campus and off-campus?
In limited circumstances, I do think Tinker can apply to off-campus speech. As I said before, gun violence is real, and we want schools to be able to step in. But here, we don't see that. So if we're going to create this nexus where the school can discipline because there's a probability it would reach campus, why would we follow the First Amendment at all? That's really, and the school has any nexus that anything could be brought to campus because of a probability of it coming to campus. In addition, we see that where Tinker has been applied to off-campus speech, it's just not factually relevant to this case. There was a Fifth Circuit case in Ponce where a student had a notebook where he wrote about Columbine-like shootings. He brought it in his backpack to school, and then the school had looked into it. They had found it in his backpack. They called the police. They had a threat assessment. They searched his locker.
If a speaker gives a note to a student and says, or a sheaf of notes, it says, distribute this around school, but he gives it to the student off campus, that would basically be reachable by the school, right?
In that instance, it would be because he gave it to another student. But here we don't see that he distributed it.
And we know that the student here, Mr. Bell, put it in an area that he knew other students would see because they're his Facebook friends. So what's the difference between handing somebody a sheaf of leaflets off campus and saying distribute them on campus versus putting it on Facebook? Realistically, he knew it would get around campus. Am I wrong?
Well, Your Honor, in your hypothetical, he had told the student to distribute it on campus. But in this situation, he didn't tell the students to play it on campus. So there it would be a different situation where it may have not reached campus. But in your situation, you're looking at intent. The student intended for it to reach campus in that model. Here, his intent was to create awareness of an issue. Whether that occurs on campus, there's a chance of that happening.
You know, go ahead. When you started out, the first thing you talked about was the Tinker test. And the Tinker test focuses on disruption in the school as the evil to be combated here. Do you think that's the right focus?
The Tinker or the
Tinker test focuses on substantial disruption in the school itself as part of the test. Do you think that's correct? Should we continue with that test?
Well, yes, Your Honor. I think the substantial disruption is important because I do think schools know, if there is a substantial disruption at their school. However, I would like to add a piece to the Tinker test, which states that it would have to have an adverse effect on the school community. Here, the substantial disruptions that the school states are that coaches had to alter their teaching style to avoid the appearance of sexually harassing female students. Now, that alteration should have never even happened. I don't see that as a substantial disruption. In fact, that's a good change that the school would put in place to not have students.
Well, let me. I'm sorry. One more question.
Yes.
You would agree the First Amendment is a balancing test, right? It's not absolute.
Yes,
right?
Your Honor.
And so you've talked about the Me Too movement and sexual harassment, and we've asked you questions about dangers in schools and guns in schools and threats like that, right?
Yes.
So how does the school supposed to balance all that? And shouldn't we defer to the school?
Yes, Your Honor, the school can look at the situation that's presented to them, but here we don't see that. What the school was focused on here was his speech, his intent. The school had opportunities to, ask him about the gun violence, search his locker, see if he had a gun, but instead the actions they took were they were disciplining him because of his bad words. One of the disciplinary committee members said, "You're a good rapper, but censor your bad words. Those are bad lyrics. Think about that the next time you write your rap."
I want to go back to your standard. If you're saying it's tinker plus an actual adverse effect, does that mean the school district or the school has to wait until something bad actually happens before they can impose some type of discipline?
No, Your Honor. An adverse effect can be like the other cases that have applied Tinker to off-campus, the limited circumstances where they have, where there was teachers taking medical leave. There was, police involvement to assess whether the student was a threat or not. There were preemptive actions to determine the situation that created an adverse effect on campus. So they do not have to wait until it's too late. Of course, we wouldn't want a standard like that.
So then what precisely is the test? Tinker plus what?
It would be Tinker plus with the substantial disruption showing that this disruption had an adverse effect.
So you're saying there has to actually be a disruption, though. They can't just stop something before the disruption happens. When they perceive a disruption is likely, they have to wait for the disruption.
Well, Your Honor, if it was on-campus speech, they could stop it before it happened. But
for the off-campus.
If it was totally off-campus, then it would have to some way get to the campus, which would cause a substantial disruption. So yes, it would have to reach campus as well. In addition,
what if the facts, as we got them, showed that what was disrupted was the teacher's ability to teach in their normal style, and the function of where they're at is to teach, since it's a school?
Yes, Your Honor. So they had to alter their...
Isn't that a substantial effect?
It would not be a substantial disruption if you're altering your teaching style to avoid appearance of sexual harassment, no.
That assumes the truth of the accusation.
But that's what the record had stated, that they had to, now that people were watching them, they had to act differently around female students. And 5 female students came forward with affidavits saying that the coaches had been touching them inappropriately, saying things about dating them if they were older, very disturbing things. So
they're very disturbing allegations, but there was no fact finding in this case that the teacher actually committed them. That's in a different case that's not in front of us. So if the teacher's teaching style was substantially affected, and we don't know if the allegations were true, isn't that a substantial effect?
No, it would not be a substantial effect. I think it's a good question for the jury to determine whether that constitutes a substantial disruption. But in addition, it's those are the only things they stated. That's why I think the adverse effect test on the...
So you acknowledge that it might constitute a substantial disruption if the teacher were forced to change his or her teaching style?
No, Your Honor, it would have to be an adverse effect. If there was an adverse effect on the school community because of this altering of a teaching style, then yes, but here there was no adverse effect of them changing their teaching style from alleged inappropriate behavior.
What if it was hate speech that was done off campus, hate speech against blacks or against women that was done off campus, and it changed how teachers taught because of the hate speech? They became more timid.
Yes, Your Honor, we would have to assess whether there was a true threat in the hate speech, but also that is just factually different to the case in front of us, and we don't have instances of hate speech.
But what I'm getting at is if you're looking at the content of the speech off campus in order to make your argument, and maybe you like this speech better than you like hate speech. And if you're asking us to make a decision based on what speech we like or don't like.
Your Honor, it would have to have an adverse effect on campus. It would have to show there was a substantial disruption off campus, but it creates a slippery slope depending on how wide we cast this net. If it's because a student is voted a certain way or their beliefs, if a school is allowed to monitor that, then that's a very dangerous chilling effect we could have on students' First Amendment rights.
So if the students in the school were scared, a substantial number of them were scared by these lyrics, and rap song or not, would that be a substantial adverse effect?
If the students were scared, yes, but they weren't scared in this case. So here we see the students acted just fine.
What if the teachers were scared?
It would determine if it affected their ability to teach in the school environment. We see the 2 teachers implicated in the song. One felt it was just a rap, it was nothing to worry about. The other one stated he felt scared. The only tangible action we have of that is him walking to his car differently after a basketball game. That doesn't necessarily substantially disrupt the school environment.
But if he's scared, if he really is scared, that will disrupt his ability to teach, won't it?
It may affect his ability to teach, Your Honor. However, here we don't see that that was the facts of the case. We see that he was teaching, he altered his style to avoid appearances of sexual harassment. And in addition, we just see that he went to his car differently. In conclusion, Mr. Bell, his ends justified his means. His rap brought awareness and the coach's conduct changed. In a time where we teach kids that if you see something, you should say something, Mr. Bell did see something and spoke up about it. I think we can all agree that alleged sexual harassment should not be happening. He was expressing his views through his art form that he knew. He was an aspiring rapper. He's wrote raps before. We don't want to limit students' speech off campus. And in addition, we need to show other students that they can speak their mind and that schools should not have that overreach just for anything that they dislike, because dislike is not enough for the First Amendment, and that's why we have a First Amendment. Thank you.
Thank you.
Thank you, counsel, and you have a remaining 3 minutes for your rebuttal argument. Good afternoon, and you also have 20 minutes for argument.
Thank you. Ms. Chief Justice, Your Honors, may it please the Court. Respondent requests that this Court uphold Justice Barksdale's opinion rendered in the rehearing en banc from the Fifth Circuit, finding that the school board appropriately disciplined Mr. Bell after he publicly posted a rap with explicit and violent language directed at 2 coaches specifically. The legal doctrine of in loco parentis dates back to our U.S. courts in 1837. This doctrine gives schools the right to discipline students, enforce rules, and maintain order, including regulating students' speech. The interests are maintaining safety and making sure that the educational environment is fruitful for the students. Over a century later, this very court affirmed in loco parentis in Bethel v. Frazier and Morse v. Frederick, stating that the First Amendment does not provide students absolute freedom to their speech. In fact, it has to be weighed, the First Amendment speech of the student has to be weighed with school officials' duties to teach students appropriate behavior and how to act with each other, as well as keeping those students safe.
Isn't Morse really just a no drug advocacy case? Aren't you extending Morse really beyond what it really does?
No, Your Honor. Morse is certainly an exception to Tinker with very specific facts. However, it comes from the lineage of Tinker, if you will. And so the essence of in loco parentis, meaning that the schools are in charge of keeping school.
Where was the disruption in Morse?
Physically, it happened on campus, Your Honor.
Okay. So then it's not really part of Tinker. It's not part of the Tinker line.
It is part of the Tinker line, Your Honor, in the fact that it incorporated a lot of the same framework. It certainly incorporated a lot of the spirit of Tinker, if you will.
All right.
We certainly don't, Respondent does not assert that Morse is factually similar to the facts here. However, again, the spirit is in line with a school's need to keep students
You began
safe.
by stating there was explicit and violent language. Does Respondent contend that there was a true threat made in the rap song?
Your Honor, Respondent does contend that there is a true threat, although we don't think that's the appropriate test to use here.
Why not?
We think that Tinker should apply, or at least a variation of the Tinker test should apply. So of the majority circuits who have addressed whether Tinker applies off campus, most of them have found.
Are you conceding that there was no threat?
Yes, sorry, Your Honor. We do not concede that there isn't a true threat, but we don't think that is the appropriate test. The first test that should be applied is Tinker.
If we rule against you and say that Tinker does not apply to off-campus speech, tell me briefly why you think there was a true threat here, because I didn't see in these lyrics that that Bell was saying that he would somehow bring about harm, just that harm might result. So if we don't apply Tinker here, how is there a true threat?
So in the Wetz analysis, the court looked at three main things. First, the context of the remarks. Secondly, the conditional nature of the statements. And thirdly, the reaction of the audience. So in short, to not belabor any point here, the context is incredibly important. In this case, we're looking at a student directing their speech at a school. In Wetz, it was a bit different factually.
I mean, Wetz, the guy said, you know, I want LBJ in my sights. But here, was there anything in this rap song in which Bell said that he would cause harm, either directly or indirectly, as opposed to merely predicting harm, like, say, the family of the victims that the teachers assaulted?
There was one line that I could quote from the rap where Mr. Bell himself said, and I want to quote this directly, quote, "Run up on T-Bizzle, I'm going to hit you with my Ruger," end quote, Ruger referring to a type of gun. And so language like that, I mean, that wasn't the only line with very explicit
Isn't that
language.
an if-then line? If you do that, then I'll hit you with my gun?
Yes, Your Honor. That was in addition to other lines of quote, "You effing with the wrong one, going to get a pistol down your mouth," end quote, quote, "Better watch your back, I'm gonna serve this N-word like I serve the junkies with some crack." So taken together, it's important to look at all of the lyrics. The fact that the coaches were called out directly by name is also important in the Wetz analysis. They mentioned that referring to something vaguely versus directly also should be factored into that analysis. In this case, however, we are arguing that the circuits have appropriately used the Tinker framework and adapted it to off-campus speech.
Do you think the Tinker test should be continued?
Should be continued, Your Honor?
Yeah, should we adopt the Tinker test again?
Yes, but a slight variation of it in order to accommodate the technological advances that have taken place.
And what specifically is that variation that you're urging?
Certainly. So this is a mixture of the Second, Fourth, and Eighth Circuits tests. And first, the question is, was the speech targeted or directed at the school? The following question is, did the speech threaten, harass, or intimidate the target of the speech? And thirdly, and this is somewhat of a two-part test, was there a substantial disruption, or could there foreseeably have been a substantial disruption? So many of these things came up in the petitioner's argument. We do disagree with the need for an adverse effect to take place because that, quite frankly, ties the hands of schools in order to make a decision.
So under the test you're proposing, if Mr. Bell had gone to the local school board meeting and at the local school board meeting had said, there's coaches engaging in inappropriate sexual conduct with girls at the school, and as he said in the rap song, he does it differently with the black girls than he does with the white girls, and these are the names of the two coaches. And so, is that permissible under your test, or is that barred? One would think that it would substantially affect the two named coaches.
And this is not being said in a musical context or any of that, Your Honor?
Just goes to a public school board meeting and on the agenda stands up to speak and says, I want to tell you about this at my school.
Your Honor, that would be different from the test here. We definitely want to maintain the balance between a student's free speech and a school's ability to take proper action. The difference between the hypothetical that you provided is that there was no mention of gun violence or threats or potential death.
But that wasn't part of your test. Your test said, did it have a substantial effect? Was it directed at the school, and did it have a substantial effect on the school? Or did it harass, and was there a substantial effect? And I could see speaking publicly at a school board meeting on those very sensitive topics as meeting all three of those criteria.
You are correct, Your Honor. And as Petitioner mentioned, the Me Too movement and sexual harassment is a very important matter. However, we don't think that it would rise to the level of threatening, harassing, or intimidating the coaches, especially if, assuming arguendo, that they in fact committed those crimes.
So let me ask you this, following up on my colleague's question. If Mr. Bell went to the school board meeting and says to the school board, I have something very important to tell you about. You need to know about this for the safety of the students. But I'm a rapper, so I'm going to tell you in my language. Let me rap it to you. And then he does the exact same song to the school board. Would that be something that he could then be punished for?
Your Honor, I think the factual difference there is there would be an opportunity to immediately ask Mr. Bell about his intentions and what he meant. Aside from the fact that he would be physically on campus, which would bring those facts closer to the Tinker test in and of itself there. And the fact that it would be targeted at the school in a very direct way.
That bodes against him. That bodes in saying that him saying his rap at the school board meeting is going to get him in more trouble. So you think that if he goes to the school board meeting and says, I've got something to warn you about with your teachers. This is very serious. You've got to take this seriously. And then he does that rap. Would he then be able to be punished by the school for saying that rap to the school board? That's, I think, a yes or no question at first, but then, of course, explain.
So, I'm sorry, could you just summarize your question, Your Honor?
He goes to the school board meeting and says, you've got some teachers doing some pretty bad stuff. I want to tell you about it. But I'm a rapper, so I speak in rap. Here's what I've got to tell you, school board. And he does the exact same rap that he's now been punished for. Could the school board punish him for that or not?
Under the Tinker framework that we are proposing, it would depend, again, on the factors being met. I think in that situation, we would have to evaluate the threatening, harassing, and intimidating nature of that statement.
Well, let me ask you this. Is it an objective test or a subjective test about harassing, threatening, and intimidating?
It's a bit of both. So the second prong, Your Honor, has to do with how subjectively the target felt.
Well, why should that matter? Why should there are words on a page. Why should it matter what the person who's saying those words means or thinks?
Your Honor, the cases like in the 11th Circuit, Boehm v. Fulton County School District found it dispositive that the teacher...
Well, I get that, but we're the Supreme Court, so we can figure out what we want to do here. So why should I'm having trouble understanding why the subjective intent of Mr. Bell should matter at all, and why objective tests shouldn't be employed.
The subjective intent of Mr. Bell or the target of the speech, just to make sure that we're on the same page.
I thought you were saying that, in response to my colleague's question, that if it was in a school board meeting, the people would have a chance to ask Mr. Bell, well, what did you mean by this, and ask questions. And so my question is, why should that matter? The rap song says what it says. Why should it matter what he's thinking? It's what the effect is on other people, isn't it?
Yes, Your Honor. And I think potentially we got lost in communication. So the subjective intent, not of Mr. Bell in this case, but of the targets is what's important here, because we are taking into consideration the environment and how the environment is feeling. So
if you have what they say is, a very soft egg, then that makes it worse? Or are we looking at, again, an objective test of a reasonable person?
So the third prong calls into question a reasonable standard from the objective standpoint when we're comparing it to school boards. But in the case of feeling threatened, harassed, or intimidated, yes, it would be a matter of the eggshell plaintiff.
Well, I think that Mr. Wildman and Mr. Rainey would probably be more upset if this was said at a school board meeting. Do you disagree?
Not necessarily, Your Honor, and I think it'd be hard to predict what they would feel from that. I mean, I would...
It'd be a jury question, huh?
Potentially, Your Honor, but I do think that the fact that it was posted on YouTube to millions of people would be, I think, a bit more public than a school board meeting where it would probably be kept under wraps. So I do think that the judge in the lower court and the rehearing in Bonk correctly...
What if Mr. Bell told the news media, by the way, come to the school board meeting, there'll be some really important disclosures made, and we were packed with news media back there?
How would that impact...
Would that affect the First Amendment analysis here?
I think under the Tinker test that we are proposing, it would not necessarily get to any of the prongs regarding school safety. It would certainly make it more public. YouTube is just as public as a news media source would be. However, I think it is important to mention that the foreseeable substantial disruption is really the meat of this analysis here, because unlike Petitioner mentioned, we don't want schools to wait until there is an adverse effect to be able to take action.
What's the level of disruption you're talking about?
So here, just keeping in mind that this court in Wood v. Strickland mentioned that deference should be given to school administrators' decisions to regulate, and federal courts shouldn't necessarily override those decisions. Here, it's a combination of case law and facts. We do believe that the motion for summary judgment was properly granted. There was no issue of material fact. But looking to factually similar circuit cases in Wisniewski v. Board of Education of Weedsport, a school was found justified, and also for motion for summary judgment standard, that a crudely drawn depiction of a teacher being killed was enough to rise to the level of causing a foreseeable substantial disruption, even though it was transmitted over the internet. And so cases like this, as well as Weinar v. Douglas County.
Well, doesn't that meet the true threat standard? So you don't need a special Tinker standard?
Not necessarily, Your Honor, not in this case. Again, I think it's more important to distinguish that First Amendment speech in schools have a separate sort of analysis going back to the special environment that it is a school being a special environment.
I'm having the same trouble I had in the very beginning. I don't. Can you explain why you're not putting more weight on the true threat test?
So the truth threat, we think, doesn't properly take into consideration the policy concerns of school safety. Factually, Watts was adults. Here we're talking about children and students. And it was at a public encounter, a rally, if you will. And it would be a very tenuous connection to make, Your Honor.
If a student off campus says, I'm going to shoot up my school or blow up my school, I'd want the school to be able to deter that and probably a threat analysis might do that. If a student wants to say off campus, there's some really bad stuff being done by teachers to other students, other things being equal, I'd want the student to be able to say that without discipline. How do I balance these two?
We propose that the Tinker test or the variation of the Tinker test would balance those needs.
But then you'd lose in this case, wouldn't you? The test may be right, but applied to this case, that's what Mr. Bell was just doing.
No, Your Honor, we respectfully disagree on that. To get back to the point, the facts show that Mr. Bell targeted his speech at the school by mentioning the coaches by name and stating that he didn't go to the school administrators, but posted this rap song because he thought it would be a more effective way of shedding light on the situation, presumably having the school take action against the coaches. In addition to that, the foreseeable system...
And don't we want to protect that? Don't we want to protect his ability to do that?
Yes, Your Honor, but we want to encourage students, especially children, to do so in the appropriate manner and make sure that they're learning that the internet is a very... it's an outlet with digital permanence, and their words matter, and what you say matters, and reporting incidents is very important.
So why can't the school just use this as a teaching moment, but not discipline the speaker?
Your Honor, I can't speak to the specifics of exactly what happened in those meetings, but the school did take appropriate action once the coach reported the rap. They spoke to Mr. Bell and sent him home that day for safety precautions. They looked into it again. They spoke to him. They asked him questions. There were multiple hearings and meetings where there was an opportunity to assess the situation. And we think that the courts should defer to the school board in these situations because they know all the facts and they were there.
The petitioner argued that this is just a rap song. And so that pretty much covers it. And so it's protected. It really wasn't serious. What's your response to it's just a rap song argument?
I would fall back, Your Honor, on the fact that in the technological age, in an age of cyberbullying, in an age where information travels so much quicker and physically to other bounds and reaches corners that information used to not reach as quickly, we need to teach students that their words matter. And I'm sorry to repeat myself, but their words matter. And the weight of their words, especially when using gun violence and very loaded curse words, can have an impact on their life and the lives of others. And again, digital permanence, what goes online.
So you think there is no exception for rap songs? Is that what you're saying?
Not necessarily, Your Honor. Rap songs that are more appropriate and suitable for teenagers and children, meaning things that don't necessarily threaten coaches directly with having a pistol shoved down their throat or getting hit on the head with other objects.
Why isn't that metaphor?
Why isn't that metaphorical, Your Honor?
Namely that coaches and teachers, what you've been doing here is so bad, you're going to have some really adverse consequences happen to you. you're going to get fired, you're going to lose your teaching license. And for a rap singer, the pistol to your throat in a rap song is metaphor. What's wrong with that argument?
It is correct that art, and especially lyrics and music, should be taken in context and shouldn't be taken literally every time. What's different between commercial rap and school rap is that here you're talking about a teenager who is underage, or his audience is potentially underage, and again is addressing the school directly and targeting the school directly, not only with the lyrics, but also with the images and his intent, which was expressed at disciplinary hearings.
If a rapper threatens to shoot police, can that rapper be criminally prosecuted consistent with the First Amendment?
No, Your Honor.
Why not?
Because presumably this is an adult artist who already has a career and is commercially singing to the public and in general, and not to a smaller audience, and is not a child as well.
But your first argument was that Mr. Bell was targeting this to a small audience, and that was bad. Yet your answer to Judge Simon's question is that if it's targeted to a large audience, that's far better.
I'm sorry, Your Honor, if I gave you the impression that I meant small audience. I meant targeted audience, specifically the school and the students who are at the school. So, for example, Mr. Bell's Facebook page had 1,300 Facebook friends, many of whom were Itawamba High School students. And so the commercial nature of a rap song that's published for the public is very different than a student's rap song who was published and called out specifically a school
So the broader the dissemination of the threat, the less fearful it is, and the narrower the dissemination of the threat, the worse it is?
Your Honor, my time is up. May I finish my?
Please.
So Watts addressed this quickly in passing, mentioning that if the speech was directed to a wide audience, that the threat would be sort of reduced. And so in that sense, yes. So the larger the audience, the more broad or general the audience, I'm assuming it's an adult audience, the less of a threat it will be. Thank you.
Thank you.
Thank you. Madam Bailiff, I assume there's 3 minutes remaining for rebuttal. Thank you. Counsel, you have 3 minutes remaining.
Thank you. Your Honors, I'd like to address 3 points that Respondent made. First, Respondent said that Mr. Bell's words matter, and they do matter. The point of this rap was to bring awareness to something that allegedly should have not been happening on campus.
So I want to follow up Justice McCloud's question, which relates to your first point. You said, well, Me Too movement, sexual harassment, obviously bad. Things happen. And so therefore, we should take that in context. Right so far?
Yes.
Okay, so what if the content of the rap was, I don't like my teachers, and then had the same references to violence in it? What would be the result there?
Well, Your Honor, that wouldn't have any public concern in it. Here we see the point of the rap was the public concern of the alleged sexual harassment. So that would be a different scenario, as you indicate. It would be a different outcome. It would depend on what the specific lyrics of the rap, if you mention the name.
The test talks about political, social. So think of a social thing. I don't like my teachers.
That wouldn't be a public concern. It would be the own personal's specific feelings towards that teacher. In addition, the Respondent talks about Wisniewski, and that case is exactly what we don't want to happen. There, the police had said that the student's image was not a true threat, and the police said it was nothing to worry about, yet the school felt that since it had a sufficient nexus to reach campus, that they could discipline for it. So here we see the overreach of the school just going into the realm that they should not be in, even after being told by police threat assessment that it was not a true threat. Here we don't see any threat assessments here as well.
So what's the difference between your proposed tinkered with tinker test and the school's proposed tinker test?
Yes, Your Honor. So the way that the school proposes it is that, anything is nothing's off limits. Where do we stop?
They said directed at school. Was there a substantial disruption? And
threat, harass, or intimidate.
Thank you.
Yes, Your Honor. The threat, harass, or intimidate is coming from their school policy, which they have no facts to back up of the threats, intimidation, or harassment. After the first hearing that they had with the student, Mr. Bell actually didn't even know why he was being in trouble because they were so focused on his words.
But what's the difference with the Tinker test you're proposing and the Tinker test they're proposing?
Mine is that you need to have that adverse effect on campus because here we see there was none, Your Honor. We see that, the school said there was a substantial disruption, but we don't really know what that means. That's why I'm proposing that it must show an adverse effect on campus because then it can be disciplined for. In addition, we see that this could cause a chilling effect if we allow this kind of speech to be disciplined for. May I finish my sentence, Your Honor?
Of course, counsel.
Thank you. The Supreme Court in Thomas said, when does it become something that we dislike, that the school dislikes, and that's why they're disciplining for it. And we don't want that to happen. Therefore, I respectfully request that you reverse the Fifth Circuit en banc decision. Thank you.
Thank you very much, counsel. Court is adjourned.
As the judges take some time to deliberate, I want to use this time to say thank you to the many individuals who have helped make this competition possible. So I'd like to start off by thanking our sponsors, Jones Day and Experian. They've been the sponsors since the beginning of this program, and for that, we are extremely grateful. Please join me in thanking them. This year, we also had the largest competition in UCI law history. Over 60 individuals started the competition, which required professors to grade 30 briefs and judges and practitioners to preside over 25 sessions of oral argument across 15 nights. Thank you to all of those practitioners, professors, and judges. Additionally, thank you to the 1L bailiffs who kept time throughout those rounds. I'd also like to thank our event coordinator, Jillian Henry, for her assistance in running this competition. I'd also like to thank Professor Jonathan Glader, our resident expert in education law, for his invaluable help in writing the questions presented and in reviewing drafts of the bench brief. I'd like to thank Senator Dunn for organizing the practice rounds and Professors Paul Hoffman and Robinson Dorn for providing brief writing and oral argument training for our competitors. I'd also like to thank our advisor, Professor Croskery Roberts and Dean Richardson, for their support of the program. And finally, I must say a huge thank you to the 5 other members of the Moot Court Board, Katie Rice, Desiree Murray, Chris Smallwood, Farnaz Salesi, and Emily Satifka. Running this competition takes a tremendous amount of time, dedication, and heart, and the competition could not have existed without you all. Without further ado, please join me in welcoming Professor Croskery Roberts, who will announce the winners of the brief boards.
Hello. I always have to find them down here. All right. Before I announce the runner-up best brief and best brief awards, I want to say, I know we've already thanked the board, a couple of people have, but I want to give a particular thank you to this year's board. You just heard that this is the largest competition ever. I've been doing Moot Court since I arrived here 7 or 8 years ago. This is one of the smallest boards that we've ever had. So we this year had one of the smallest boards in the history of our law school handling the largest competition ever. And they did so with grace and hard work. And I can't even tell you how grateful I was that they were working on this problem this year. So I just wanted to send my own personal thank you to this small but very mighty board. Yeah. And I now have the amazing honor of announcing the runner-up best brief, and I apologize in advance if I mess up names. I'm gonna try, I really am. And our runner-up best brief winners are Jazz Kabula and Paige Cavendish. You could come on up. Yes, come up. All right. And then you will get pictures and everything. All right, so We have University of California Irvine School of Law 2019 Experian Jones Day Moot Court Competition runner-up best brief. I'm getting out of the way. In the way. You go. Thank you guys so much. And then the awards, you didn't know this, for the 1Ls in the audience, you didn't know this, but one of your greatest goals in life will be to earn a silver plate. All right. And so for the 2019 Experian Jones Day Moot Court Competition, our best brief winners are Emily Johansson and Salma Al-Haraki. Congratulations, guys. Thank you. You guys slide over here. All right, and now what we do is we awkwardly wait for the judges to make their decisions. So feel free to chat amongst yourselves, and we will let you know when they are ready to come back, and court will be in session.
Please be seated. I'm just going to speak briefly, and I am going to stand up for this portion of it so I can see the people in the front row, and that's the only reason that I'm standing. Thank you so much to Dean Richardson for inviting me and for inviting us. Thank you to our bailiff for keeping time. I was anxiously looking at you. And thank you. Where are my presenters? Okay. Thank you. I'm sorry.
Well, they're there.
See, it really helped that I'm standing up. Terrific presentations, both Ms. Aguiar and Ms. Christie. We all agreed on that, and we'll be giving comments to you after that. But in announcing the best oralist first, very close and very competitive and a very difficult decision for us. But we do think that Petitioner's Counsel, Ms. Christie, is the best oralist in this argument. And we thank Ms. Aguiar so much for best runner-up. And I'm going to turn to my colleagues, Judge Simon first, to give comments.
Thank you. And what's that old line about Judge Simon, please feel free to stand up? And I say, I am standing up. By the way, it was so close between the two of you. So anyway, you both were terrific. I just wanted to share 3 general comments. I don't really have specific comments, except maybe one, but I want to share three general comments. The first is, these were really tough questions, tough problems. By the way, I already told this, whoever is responsible for crafting this problem did a superb job. There is no easy answer to these problems, and both of you did a beautiful job of struggling with the really, really tough questions. First suggestion, though, is as you're preparing your responses, think about the concept of a premortem. That's something that's working its way through the terminology in the legal practice, previous in the business practice, and the scientific community. And that basically says, if my argument is not going to be accepted, what's the most likely reason? Or in other words, think of the toughest questions against your position that you don't want to be asked, and make sure you've got your answer nailed. Some of your answers were superb, really excellent. Others, I could sense some hesitation. Make sure that you've anticipated all of the possible hard questions as best you can, and then just nail those. Second point, although I think you did better than most of the advocates that I've seen, and I sit regularly in the district court, a lot of trials, a lot of pretrial arguments. I've also sat by designation with the Ninth Circuit, so I hear some appellate arguments. I think you're better, or both of you are better than many of the advocates that I've seen in court already. But the one thing that I'd urge you to think about that'll make you even better is do it more in a conversational style. You did a superb job, quasi-debate style. Try to make it more conversational. I know that we kept interrupting you. That's just the way this works. But to the extent that you can realize that you're just having, maybe visualize you're having a dinner party with a couple of people and they say, hey, I hear you're arguing a case. Tell me about it. And you tell them about the case. And they start peppering you with questions. And you give them a response in your dinner conversation. That type of conversational style is the way the best appellate advocates do it, at least from my perception is. Third point is realize the difference in your context of the audience, in that now you're speaking ostensibly to the US Supreme Court, so the other decisions of the circuit courts are less important. Past decisions by the Supreme Court are more important. But the most important thing is we're trying to figure out the answer and the rule now going forward. And so when I ask, and I think, Ms. Christie, when I think I asked you a question that sort of expands what the rule would be, and your answer was, well, that's factually different from the case before us. I know that. I'm trying to figure out what the rule is going forward. And so feel free to either help me figure out what that rule should be going forward, or steer me in a different direction towards a different rule. But it's not that helpful to say that's factually different from the case before us when you're speaking to an appellate court. On the other hand, when you're speaking to a trial court, that's the key. That's where the bulk of the game is. We don't, as a trial court, we don't write things with precedent. And there you've got to make sure I understand the facts before me, but not for the appellate court. So there's a difference there. That said, these are minor points, 3 minor suggestions. Both of you were superb.
Thank you.
Okay, so what he said, that's my comment. I'd like to join my colleagues in thanking everybody, including the audience. It was quite an impressive turnout of members of the community and students and faculty, and it's really a delight. I will say it's the first time I've ever had that many people stand up for me at one time. So that was kind of cool. So let me make a couple, big points from 30,000 feet. I agree that it was close and that both oralists were terrific in every way. I can't see them, but I know they're down there. Okay. So I am going to stand up just because I'd like to see you when I talk to you. You're terrific. I think the strengths of both of you, you obviously both had a command of the subject matter. You knew what you wanted to say. You knew where you were going. So I want to be constructive. And this is just the only things I would say would be, it is really important, and especially in an appellate argument, to know what your weakest points are, and to really have an answer prepared that you've thought through and that you know what it's going to be. Because I think both of you were asked tough questions, and you both did well, but you need, as you get more experience, you will do better. That's the hardest thing to do. There's a story that one of my colleagues tells about, he was working for the public defender's office and his colleague came down the hall and he said, I got this great case, I got these great defenses, it's just fabulous, we're going to win this case. And my colleague who's in the public defender's office said something like, yeah, but what about the confession? And so that, you got to always think about, what the judges may be asking you. And you should be careful of sound bites. We live in an era of sound bites, and judges are like everybody else, and we remember things. So I'm going to say one of to each of you. To the Petitioner's Counsel, the concluding remark you made was the end justifies the means, which is, none of us would agree with that, I think. So I think you got to be really careful, especially with a closing. What is the message you want us to get? You actually had this is a really good argument. And for the respondent, as you could tell, you had a judge up here who was like struggling with why isn't this a threat? Because I believe on the merits, and we're not, you know, I think that's the strongest argument. And so I think, and then I asked you that, and you said, well, it's a tenuous connection, but you have to explain why. So those are overall, I thought it was, both of you were excellent. It was a close decision. You would have, if you could have heard us in there, you would have loved the discussion, because we were very complimentary, and we appreciate all the efforts. To get this far in this competition is really a credit to both of you, because I know how competitive it is. I kept getting these emails from the school about the preliminary rounds and this rounds and the other rounds, so I know how hard you've worked. And so really congratulations to both of you. You've just done a superb job. You've made your school proud, and each of you. And I wish you both the best in your legal careers. Thank you.
I started out at the public defender's office, as did Dean Richardson. Coincidentally, it was the same public defender's office. And we would call the story you told, the confession, we would call that the bad fact. Every case has the bad fact, and that's the one you're going to get asked about. So that's the one that you have to prep for. Big picture, I wanted to say, Tinker was decided, I think, 1969. I was in high school 1968 to 1972 during the Vietnam War, and we wore black armbands. I thought Tinker was this wonderfully pro-First Amendment case. I had always thought of it as a case that expanded students' rights. And I know here, when the question is whether to apply Tinker or whether to apply a test that's not school-specific, Tinker, of course, was viewed as the test that restricted students' rights, but big picture, that was sort of difficult for me to get when I started looking at the problem. Great presentations. Both of you started off with the relief that you wanted, and I wanted to clarify it with both of you. And I know with Ms. Christie, your answers basically took away my follow-up questions because you had thought it through enough so that you were seeking a jury trial and you weren't seeking reinstatement of the Fifth Circuit's first opinion where the cross motions for summary judgment were granted. So I think knowing the relief you want is key, and I thought you both did a good evaluation to ask for the relief you were asking for. And of course, when you're coming to the Supreme Court, and you know we can change everything, we could change true threat doctrine, we could change Tinker, you've got to come with a proposal, and you each did come with a proposal for the Tinker test. So I thought that was excellent on both sides. I'm not sure that each of you thought through exactly how that test would apply to different really difficult factual scenarios. And for the scenarios that I had as hypotheticals in front of me, I had two of my clerks read through the problems and draft questions for you as well. So I was really looking for the toughest ones. So you can thank them. But other than that, I think that you had a lot of what you're supposed to have in mind beforehand, and I agree with everything else that's been said. Terrific presentations. Thank you.
I just want to thank, once again, all three of our judges for taking time out of your very busy schedules to be here to join us and to ask incredibly tough questions of our two finalists. So thank you so much for all of the feedback that you've given, the very thoughtful feedback, for the tough questions, and for the help that you sought from your clerks to write those questions, all of it. So can we give them, once again, a hand?
Thank you.
And now you can remain on the bench, and I'd like to welcome our Vice Dean, Bryant Garth.
Thank you. Mine is the wonderful pleasure of being able to give you all the recognition on the podium. And I think we have awards in. They're under a sea of. So appropriately, Tiffany, we will start with you for second place. And now this year's winner. Congratulations, Paige. You can come up. You want pictures with them both up here? Yeah. Okay. Okay, that's fine. Okay, I have one big task to do in addition to thanking you all for being here, and that is to remind you that there is a reception that starts after this. And then I do want to say two things. I want to thank the judges for taking a little while in their deliberations. Because I was sweating too much, I wouldn't have been able to come up here because I was trying to answer the questions as they were being asked, and I would have failed miserably. So thank you for taking the time. And the last thing I want to say is those of us in the administration, and I'm very happy that I get to be the one to say this time, these are the kinds of events that make us so proud to be part of this community. Stellar arguments after a stellar competition, support by the school here. Those are all the things that make the school special. So let's celebrate now with our reception. Thank you.